Hello everyone. Okay, so we were discussing, the patentability and the issues within the patentability of the AI generated intellectual property in the context of WIPO's conversation on IP policy and IP policy and this what do you call artificial intelligence. So we have seen in the case of patent or the patent regime, we have seen the inventorship and ownership. We have seen patentable subject matter and patentability guidelines, and the third one was inventive step or non-obviousness. So here we were looking at the concept of non-obviousness. So let me make it a little simple for you. What is non-obviousness, or what is the requirement of non-obviousness? Non-obviousness requirement is that whenever there is an application for the registration of a patent, that invention should not be obvious to the person skilled in the same art. So for example, if you have made a sewing machine, okay, which is working faster than the usual sewing machine, it has some technical or some mechanical aspects are involved within. Now when you are claiming a patent on that, the patent examiners will see whether this invention is actually an invention fulfilling a new and taste novel, if whether it is novel, whether it is the utility, and whether it is non-obvious. That means whether some other mechanics who are also working in the same field, whether it was obvious to them that okay, I can also create this, or it was very new, right? So again, it can be seen together with the novelty. So whether it was something different, or it was not known to the persons who were skilled in the art, so or it was not obvious to the persons who were skilled in that particular art, that has to be ascertained while giving recognition, or while giving patent to any invention which is coming to the patent office. So within that, we were in this context, we were looking at the this inventions which are generated by the artificial intelligence. If the artificial intelligence is generating any intellectual property, and precisely any invention, then who should be considered as an inventor and honored? Who should be given, whether such invention shall be considered as patentable or not, and whether such inventions, if considered as a patentable, and if we are giving the rights of being inventor or honor to the artificial intelligence, whether such inventions would be fulfilling the non-obviousness test. And when we are talking about the non-obviousness, who would be the person that is skilled, that should be considered as a person skilled in the art? Because here it's not a human being, here it's an artificial intelligence which has to be compared with someone else, right? So the first thing is whether we can really compare it with the prior art, which was an outcome of the human being, which was existing because of the human beings, which was invented by the human beings. So whether we can compare the human beings and artificial intelligence, that's the first and foremost question. Second, if we are comparing, or we are considering them both equal, whether the person or what should be considered as a prior art, because whether we are considering the personality, whether it should be the technology that has to be seen as a prior art skilled person, or the person who's skilled in the art. That means if we are giving recognition to maybe a humanoid Sophia who has created invention, okay, who has invented something, who should be the person skilled in the art? Whether it can be a Shrut, or it should be some other robot, right? Then if it is a robot, whether that particular robot is actually having the same technology, or that technical mindset, or that whether the person is actually skilled in that particular art, that has to be ascertained. Now if we are comparing such a humanoid with a human being, then whether such person's skills, human being skills, can be compared with that humanoid, that is again a question. Then should the prior art which is existing, of course there are several inventions already existing in different fields, so should the prior art in that particular field in which the humanoid has created or invented something, should such prior art be considered actually as a prior art for that invention, because these prior arts are existing by virtue of or because of the human beings, not because of the artificial intelligence. Then what implications will have will having an AI replacing skilled persons have on the determination of a prior art. Because if we are replacing AI with the person, human beings, whether the prior art can be considered, we have just discussed it, whether the prior art can be considered as a prior art which is actually the prior art created by the human beings. And then the last question was that whether, if for example we have given recognition to an invention of Sophia, whether such invention should be considered as a prior art for all the future or forthcoming inventions coming for the registration, and then again whether it should be considered as a prior art for the human beings or the inventions of the human beings, or it should be considered as a prior art for the inventions of the humanoids or the artificial intelligence. These are the growing concerns that needs to be addressed. One another part within the patent regime, or the fourth part within the patent regime, is the disclosure. There is something called disclosure, and disclosure in the in the patent application, and disclosure of the invention after the monopoly or after the term of the protection is over, right? So patent is, of course, it is protected for 20 years in India. So what in total, so what how it would be disclosed or how it should be disclosed. Now the purpose of the disclosure is that other persons who are skilled in the art can also produce relevant or similar similar such inventions, or reproduce the invention after the 20 years when the invention is in the public domain. Now what issues such AI generated inventions present for the disclosure requirement? Because if it is, for example, if it's algorithm based invention, algorithms do change with the data, okay, do change with the what is this over time, okay. Oh, okay, algorithms do change with the over time, and with access to data. Now, for example, if 20 years back an invention was made by an artificial intelligence, and the algorithms which were considered as the disclosure part, or something which is disclosing the invention, whether such, because after 20 years such algorithms would be nowhere, would not be existing at all. So how such inventions would actually come in the public domain? How such disclosure would be made? Because this is not a human being based or human based invention that you can take some written notes or written this thing, descriptions of the invention. So you need to have the AI to give you the disclosure or disclose you the invention. So that's again a question, how the algorithms can be changed. Then in that case, if it cannot be changed, whether the algorithms be submitted to the patent offices, like how we are submitting the microorganisms when it comes for the patent. So that's again a question, in what form algorithms should be submitted. Now when it is submitted, whether there should be some there should be the interpretation of the same to be taught to the, or to be given to the human being or a person who's skilled in the art. Then in that case, the novelty may not sustain for the 20 years protection, because if once you are communicating it to someone, maybe to a person who's skilled in the art, it would not be considered as a novel at all. So, or the term of protection won't be it won't be considered as a protection of such AI. Then should the data used okay, so the data which is there should be used to train the algorithms, which shall be disclosed, and how it should be used to disclose or train such data to disclose such algorithms which are utilized, or which are the basis for the of the invention which were used by the artificial intelligence. Next is should the human expertise be asked to select data and to train the algorithms be required to be disclosed, or there shall be some human expertise who shall be given that algorithm, and that to train that algorithm to change with the time. So if 20 years back some algorithms were used by an AI to create any invention, that would be changed with the time, and after 20 years in the new form the algorithms would be available with the with the public and with the society, so it can be, it can be disclosed to the to society after the term of protection ends. So, and then there is of course one one head within the patent regime with the WIPO conversation states, which is gender policy consideration. It states that is it too early to consider these issues or these questions, because the impact of artificial intelligence on the science and technology is rapidly, at this stage it is rapidly changing, and it is insufficient. There is insufficiency of understanding the impact of what policy measures might be appropriate in these circumstances, because it is, rapidly it's changing. So what kind of protections may be, maybe given to such artificial intelligence is a question, or it's a need of an hour to discuss or determine what kind of what do you call protection may be granted to such inventions which are being generated by the artificial intelligence, because AI is rapidly changing. And then with that particular change, would it be feasible for the countries to change their IP policies or change their laws, IP laws, with the advent with all advancement that we see these days. So this was regarding the patent part in the draft issues paper of the WIPO on the IP policy and AI. In the next session, of course, we shall see the part or the issues or the concerns on the copyright regime, and then the data regime and design regime, and the likewise whatever discussions are there or whatever points are there or concerns are there, we shall discuss. So please note that there is no IP policy that we have to actually discuss, because the Indian National Intellectual Property Rights Policy 2016 is not addressing or is not giving recognition, or is really silent on the artificial intelligence or the creations by the artificial intelligence. So we have to see that in that case what are the international development, and internationally WIPO is the one which is actually working towards this, and WIPO has since 2018 started working on IP policy and AI, and after the first session the second session was due. It would definitely be be conducted after the new date will come out, and then there shall be some concrete decision probably after the second session, that what kind of protections or what kind of provisions needs to be there. The concerns are already raised or published by the WIPO on its official website. So that's it for this particular session. Thank you for listening.